she's coming to meet us because she knows that the theatrics won't work at closed doors under deposition. The reality is that she would be asked questions under oath by lawyers, that she would be subject to the penalty of perjury, and that will haunt her long after she's Attorney General. So my sense is she's coming tomorrow to try to diffuse the subpoena, but I doubt that she's going to be able to convince Republicans to have her not comply.
Welcome to the courtroom of American democracy. Tonight, the prosecution presents a case not against a criminal defendant, but against the highest law enforcement authority in the United States. The charge? Possible evasion of accountability in one of the most explosive investigations in modern history, the Jeffrey Epstein case. And now, the Attorney General stands under subpoena. Let us define the allegation precisely. The House Oversight Committee has issued a subpoena to the Attorney General, not for a routine inquiry, but for her handling of the Epstein investigation and her compliance with the Epstein Files Transparency Act. The claim is simple. The law required transparency. The Department of Justice may have delivered concealment.
And tonight, the Attorney General of the United States is under subpoena. The Washington Post reports the House Oversight Committee has subpoenaed Attorney General Pam Bondi as part of its probe of the Justice Department's investigation into deceased sex offender Jeffrey Epstein, ordering her to testify before the panel on April 14th. If Bondi honors the subpoena, she would face committee members' questions in a closed-door session that could turn contentious, given the volatile nature of the Epstein case and Bondi's demonstrated willingness to engage lawmakers in verbal combat. A Justice Department official, however, quickly dismissed the subpoena as pointless, declining to say whether the Attorney General would comply.
The forensic record begins here. A formal subpoena, issued not by political opponents alone, but by a bipartisan congressional mechanism. This is not speculation. This is legal compulsion. A subpoena is not a request. It is an order backed by the authority of Congress. And it signals one thing: voluntary cooperation has failed. Let us reconstruct the chain of events. Step 1. Congress passes the Epstein Files Transparency Act, a statutory mandate requiring the release and review of investigative records. Step 2. The Department of Justice, under the Attorney General, assumes responsibility for compliance. Step 3. Concerns emerge. Documents allegedly withheld. Identities allegedly concealed. Witness interviews reportedly missing. Step 4. Congress demands answers. The department does not provide them. Step 5. A subpoena is issued. The system escalates from inquiry to enforcement.
3 of the witness interviews about the woman who accused President Trump of rape when she was 13, why were they withheld? Why have so many of the documents been scrubbed back in March and concealed the identity of rich and powerful men whose survivors have named in the 302 forms?
Behind every redacted document, there is a victim. Behind every withheld interview, there is a voice that was not heard. The Epstein case is not abstract. It is built on allegations of abuse, on survivors seeking accountability. When records are concealed, the consequence is not procedural. It is personal. The system does not just delay justice. It denies it.
Jim Comer, the Republican chair, issuing this subpoena, and there were many Republicans who joined in the vote to subpoena Bondi. That means they are losing confidence in her in complying with the law.
Now we examine power, not partisan power, institutional power. When members of the Attorney General's own political alignment begin to withdraw confidence, the signal is unmistakable. This is no longer opposition versus defense. This is internal fracture. The power structure is shifting, and when power shifts, accountability follows. The defense argues that this subpoena is unnecessary, that the Department of Justice has acted within its discretion, that sensitive investigations require confidentiality, that premature disclosure could compromise legal integrity, and that political theatrics, not legal necessity, are driving this confrontation. We will now dismantle that argument. Confidentiality is a legal tool, but it is not absolute. It does not override statutory obligation. The law, the Epstein Files Transparency Act, created a duty to review, a duty to release, a duty to explain. If documents were withheld, the burden is on the department to justify why, not in press statements, not behind closed doors, but under oath. Because discretion without accountability is not governance. It is concealment. Let us clarify the legal framework. A subpoena compels testimony or evidence under penalty of law. Failure to comply can result in contempt of Congress. A closed-door deposition allows questioning under oath. This is critical because statements made under oath carry legal consequences. Perjury, false statements, obstruction. This is where narrative ends and legal exposure begins. Now we examine the institutions. The Department of Justice, tasked with enforcing the law. Congress, tasked with oversight. The breakdown occurs when oversight is resisted, when transparency laws are not executed, when accountability requires escalation to subpoenas. This is not a single failure. It is systemic strain, a test of whether institutions can regulate themselves or must be forced to comply. The evidence is now before the jury. A subpoena issued, compliance questioned, documents allegedly withheld, bipartisan concern emerging, and an attorney general seeking a closed-door meeting on the very day the subpoena arrives. The pattern is clear. The system did not begin with confrontation. It escalated to it. Because transparency was not delivered voluntarily, the law asked for answers. The system received silence. So the subpoena spoke. And now, the truth will be demanded under oath. The prosecution rests.